The juror in seat 23, please. This is still panel 9. And this is juror 681. Good afternoon, ma'am. How are you?
Can you hear me?
Yes, ma'am,
Okay.
I can. I have some questions for you, and then the attorneys may have some.
Okay.
But there aren't any right or wrong answers to these questions. The questions are designed to determine whether or not you can do your job as a juror in this type of case. It's something you need to know and we need to know.
Right.
So the only correct answer to the questions is the truth. Okay? So you indicated that you knew something about this case. Is that correct?
Yes.
And that as a result of that, you had formed an opinion as to whether or not Mr. Loyd was guilty?
Yes.
Can you tell me what that opinion is?
I believe he's guilty.
All right. Jurors must begin trials, all criminal trials, presuming the defendant is innocent until and if the state proves he's guilty. Could you set aside your feelings that he's guilty, or do you believe you'd start the trial thinking he was guilty?
I could not set it aside.
All right. Thank you, ma'am. State.
We move, Your Honor.
All right. Thank you, ma'am. You are free to go.
Thank you. Do I just leave?
Yep. Juror in seat, this can't be right. Oh, 27. Juror in seat 27. Good afternoon, ma'am. How are you?
Good.
Wearing the world's most uncomfortable mask.
Just a little.
Okay. I have some questions for you. So do the attorneys. There aren't any right or wrong answers to these questions. They're meant to determine whether or not you can do your job as a juror in this type of case. You need to know that. We need to know that. So that's why we're asking you the questions. So therefore, the only correct answer is the truth.
Okay.
Just tell us what you honestly think, all right? You said you had some knowledge about this case. Is that correct?
Yes.
What do you know?
I can recall, I know it's a while ago, some news coverage when there was the whole trying to find him kind of stuff going on.
Okay. Anything about that you remember?
I mean, just vague, that there was a manhunt for him.
Okay. Do you remember anything else?
I mean, I do kind of remember the whole trial. I guess it was in 2019, as you stated. I didn't really follow it, but I remember hearing a verdict.
Okay. Like hearing the verdict read on TV?
Yeah.
All right. Did you talk to friends, family, coworkers, anyone about this over the years?
I might have when the 2019 verdict came out.
Do you remember any of the conversations?
Not really.
All right. Did you follow any of it on, I guess, Facebook or anything like that?
Oh, no.
Did you form an impression as to whether or not Mr. Loyd was guilty based on all of that?
Sort of.
And what was it?
He was guilty.
Okay. Jurors have to begin trials being able to assume defendants are innocent. That's the rule for all criminal trials. Mm-hmm. Do you think you can do that in this case, or would you start the trial thinking he's guilty?
I'd have to say I'd start the trial thinking he's guilty.
All right. Thank you, ma'am. State.
We move, Your Honor.
All right. Thank you, ma'am. You are excused. Have a good day.
You too.
From panel number 10, juror number 2. Is this the right panel? No, this is 8. There's 10.
Sit.
Good afternoon, sir. How are you?
Good, good.
I have some questions for you. There aren't any right or wrong answers to these questions. The questions are meant to determine whether or not you could do your job as a juror in this case. So the only correct answer is the truth. So you indicated to me that you had some knowledge about this case. Is that correct?
Yes,
And that as a result of that, you'd formed an opinion as to Mr. Lloyd's guilt?
somewhat maybe, yes.
Okay. What is that opinion?
Well, he murdered someone,
Okay.
you know.
So to be on a jury in a criminal case, you have to presume someone is innocent until and if the state proves they're guilty. Do you think you could do that in this case, or would you start the trial thinking that Mr. Lloyd is guilty?
No, I think I could.
All right, so I'm going to give you 3 scenarios and tell me if any of them apply to you. If they don't, just say so, okay? Number 1, it's the first day of the trial, you're sitting in that chair, we haven't even started, but you're thinking in your mind, this gentleman is innocent, and I'm going to wait and see if the state can prove he's guilty, all right? Number 2, I think this guy's probably guilty, but, you know, I'm willing to listen and see if the state can prove it. And number 3, I think he's guilty, but, you know, I'll listen to the trial, and if I'm convinced otherwise, I'll vote not guilty. Do any of those 3 apply to you?
I would think the first one, I would want to be the first one, yes.
Okay. So let me move on to my next question for you, which is, you indicated that you have a personal, religious, or moral objection to the death penalty. Is that correct?
Yes.
Which one is it?
More morally, I don't know if I could, to that point, to put someone, you know, on death row, yes.
Okay. How long have you held that belief?
Probably all my life. You know.
Is that belief such that regardless of what the evidence, the facts, or the law was, you could never vote for death?
I don't know. Yeah, no, I couldn't say that. No.
Okay.
Yeah.
What could you say?
Yeah, I don't know. If it came down to it, if I had to, I guess. But I just, like I said, in my heart, I wouldn't feel like right to, you know, to do that to someone. I mean, even though the evidence might show it.
All right, and like I told you, there aren't any right or wrong answers to this, and you're the only person who knows what you can and can't do. So let me go over the process with you. First thing, someone has to be convicted of first-degree murder, intentionally murdering someone else with no justification for it. You're not insane, it's not self-defense, there's nothing, okay? You just killed someone. So the jury has to find that beyond a reasonable doubt. Now there's a penalty phase. The state's going to put on aggravators, the reasons they believe the sentence should be death. The defense is going to put on mitigators, the reasons they believe the sentence should be life without parole. You have to be able to listen to all of that with an open mind, meaning, and you need to process it and internalize it. You can't just sit there thinking, okay, put your evidence on, and then I can vote for, you know, life or death, whatever way you're thinking. All right, that's not how it works. You have to actually be open to it. When you go back in that jury room, you're welcome to discuss this all with your fellow jurors, but in the end, it's your decision. So, and take as much time to answer this as you need. If you weighed all of these facts, weighed the aggravators, weighed the mitigators, you looked at the instructions, the law in this matter, and you believed that the appropriate sentence was life without parole, could you vote for that?
Yes.
Okay. But if you believed that the appropriate sentence was death, could you vote for that?
Yeah. I guess if push came to shove, maybe. Yes.
Yeah, this is one of those situations where I'm really not trying to put you on the spot.
Yeah. No, I know.
But we need a definitive answer.
Yes.
Because what we can't have happen is that you kind of tell us yes, and then you get to the trial and you go, I can't do this.
Yeah.
Yeah. So do you need a minute to think about it?
Yeah, I don't know if I could.
All right, sir. That's an honest answer. I appreciate it. State.
State moves, Your Honor.
Defense. You may.
See my little yellow legal pad anywhere?
Hello.
Hi.
I want to be clear. No one is suggesting what we're asking of any juror is easy. Right? This is probably the hardest thing that will ever be asked of anyone. Right? And so it should be tough. If people come in thinking this is an easy decision, that would be more concerning. I think you'd agree? Mm-hmm. Death is never required. Not in any case, not in the worst conceivable case you can imagine. And so the judge went over this, the process in that second part of the trial, right? So the first part is, has the state proven Mr. Loyd guilty beyond a reasonable doubt, or have we proven him not guilty by reason of insanity? So if they fail to prove him guilty, or we succeed in proving him not guilty by reason of insanity, we don't even get to the part where we talk about penalty, because he's not guilty, right?
Yes.
So if we're in the second part of the trial, you're going to be asked, if you're selected as a juror, to decide some things. The first is, has the state proven the existence of at least one aggravating factor? Okay? Is that aggravating factor sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? Reasons for life. And the last question is death the appropriate penalty? And so that's why I think you can see, even if it's yes, 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 you never have to vote yes in that last question. You can always vote no. Does that make sense?
Yes.
And so what the judge is asking you, and in order to be able to serve as a juror on a case where the death penalty is a possibility, is a juror has to be able to give meaningful consideration to both possible penalties for first-degree murder. The life penalty, life without the possibility of parole, or the death penalty. And that doesn't mean just, yeah, I can consider it. It means consider it and potentially do one of the two. Can you give meaningful consideration to both possible penalties?
Yes, I think I could. And then, yes.
Sir, I have nothing further, Your Honor.
All right. State, you may inquire.
How are you, sir?
Good, good.
So, I don't want to belabor the point, but given the difficulty you're having with this topic, it's important that we discuss it at length. So, you told the court when it comes to the issue of the death penalty that you're not sure that you could ever actually vote for a sentence of death.
Yes.
Do you still feel that way?
I'm torn, you know, it's like, I want to do the right thing, but sometimes, you know, in your heart, you feel like you might not be able to do that to someone, you know what I'm saying, even though it should be the right thing.
Right. Even if you believed it's the right thing, you're not sure you could do that thing. Is that a not good assessment?
Yes.
All right. So you have, if I'm wrong, tell me, you have a doubt about your ability to do that.
Yes.
And that's based on your moral, did you say moral belief?
Yes, yes.
Now, given that, I think you understand that the law will never tell you that you should, right?
Yeah.
You will never be required to vote for this if you're selected as a juror. I think the defense counsel made that clear. Do you understand that?
Yes, yes.
Given that you would never be required, can you honestly imagine a circumstance where even if you thought it was the right thing, to use your words, you could overcome that moral feeling and vote to impose a sentence of death on another human being?
Objection calls for a pre-commit.
Overrule.
Do you understand the question?
You repeat it again.
Yes, sir. Given that you're never required to vote for death, even if the law authorizes it, knowing that, could you vote to impose a sentence of death on another human being, given your moral belief about that you shouldn't do that? And it's just how you feel, sir.
I would hope I could. I wish I could, yes.
But you're not sure?
Not sure.
Okay.
Yeah.
And above and beyond, trying to be honest, it's
Yeah.
a difficult topic,
Yeah.
so I appreciate it. That's all I
Yeah.
have, Judge. Thank you very much.
Let me see the attorneys at the bench. All right, sir. We appreciate your thoughtfulness, your willingness to serve, and your being here. I'm going to excuse you from this jury. You're free to go.
All right. Sorry, Your Honor.
There's no need for you to apologize, sir, at all. That you have your beliefs, and there's no problem with that.
All right.
We appreciate your being here.
All right. Thank you.
Thank you. All right. Juror in seat 13, but this is panel 9. That was the end of the folks who knew something about the case. I'm now switching to folks who've expressed issues with the death penalty. So it's panel 9, seat 13, 887. God.
In the restroom, Judge.
Okay. Seat 17, panel 9, 532. Hello, sir. Are you juror number 532?
I didn't hear you.
Are you juror number 532?
Yes.
Okay. We have some questions for you this afternoon. There are no right or wrong answers to these questions. The questions are designed to determine whether or not you would be able to do your job as a juror in this case. It's something that we need to know and you need to know. So the only correct answer is the truth, okay?
Correct.
So you indicated to me that you have a moral, religious, or personal objection to the death penalty. Is that correct?
Correct.
Which one is it?
Religion.
Is it moral, religious, or personal?
Moral religion.
Okay. How long have you held this belief?
How long?
Yes, sir.
Since I've been born.
Okay.
Raised like that.
Is your belief such that no matter what the law, the evidence, or the facts were, you would never be able to impose a sentence of death or vote for a sentence of death?
I don't believe.
You what?
I'm not. No.
Is that a no?
No.
Okay, thank you. State?
State moves.
Defense? All right, sir, thank you very much. You're free to go. If 13 is available, 13, please. Good afternoon, how are you?
I'm good, how are you?
Just well, just fine, thanks. I have some questions for you. The attorneys may have some, but there aren't any right or wrong answers to these questions. What we're trying to find out is whether or not you can do your job as a juror in this type of case. That's why we're asking you these questions. So the only correct answer is the truth. You understand? All right. You indicated to me that you have a personal, moral, or religious objection to the death penalty. Is that correct?
Yes, ma'am.
Which one is it?
Religious.
What religion are you?
Christian.
Okay. And what is your belief about the death penalty?
I just don't think that it's right. I just feel like everybody should be able to have a chance to live.
Okay. So based on that belief, could you ever, regardless of what the law, the evidence, or the facts told you, would you ever be able to vote for a sentence of death?
No.
State?
You move, Your Honor.
Defense? All right. Thank you, sir. You're free to go.
Can I know last week you discussed about like work reasons and
You've been excused.
oh, okay.
You're free to go. Yeah.
Thank you.
Sure. No problem.
Down the center aisle to the exit.
Let me see, 27's gone. I need this is the flip side, someone who said they would always vote death, I believe. Juror in seat 35, that was the indication. And this is juror 918. Good afternoon, how are you?
I'm good. How are you?
I'm doing well, thank you. So I have a few questions for you. There aren't any right or wrong answers to these questions. The questions are designed to try and figure out whether you can do your job as a juror in this type of case. It's something we need to know, it's something you need to know. So the only correct answer is the truth, okay? You indicated to me that you're a person who has some very strong beliefs about the death penalty, is that correct?
Yes.
Right. In order for the death penalty to even become an option, someone has to have been convicted of first-degree murder, intentionally killing another person with no legal reason for doing so. In other words, it's not self-defense. There's no defense to it. And the jury has to have found that person guilty beyond a reasonable doubt. You with me so far?
Yes.
If you found someone guilty of first-degree murder, as I have defined it to you, would you be able to consider a sentence of life, or would you vote for death?
I would be open to life.
Okay. So when I asked the question about folks who would vote for death, you raised your paddle. Can you tell me why?
So I'm just a person who, it's a life for a life if found guilty.
Okay.
But got to be open-minded as well, I guess. I don't know, I was just sitting back there. It's not black or white.
So your personal belief is a life for a life?
Yes,
Is that a religious or personal belief?
just personal,
Just personal? How long have you had that belief?
just the way I was brought up.
Okay. So let me ask you a few follow-up questions on that. If I added to the fact that it's a conviction for first-degree murder, as I defined it to you, and I added to that the fact that it's a law enforcement officer, would that change your answer?
For going for,
Yes, ma'am. Being able to consider life. The person
Yes.
that was killed was a law enforcement officer.
I would be considering life.
All right. And then if I add to that the fact that there's a prior conviction for murder, and that would be of a pregnant woman, would that change your answer?
That would change my answer.
And then what would your answer be?
Sorry. Death penalty, sorry.
Okay. In that circumstance, do you believe you would ever be able to fairly and openly consider life?
No.
State?
You move, Your Honor.
Defense? All right, thank you, ma'am. You are free to go. We
Thank
appreciate
you.
your service. Yeah, thanks. All right. I don't have anyone else that I made notes on. Does anybody else have that? Because I got a little confused with this one. All right. Nope. In that case, let's try and finish panel number 8. So, I think it's this one. All right, panel 8. Juror in seat 55, Juror 51. Good afternoon, ma'am. How are you?
I'm well, thank you, Your Honor. How are you?
I'm doing well, thanks. Look, I know this whole scene is uncomfortable for you. Try and relax. I'm just going to be asking you some questions, and then the attorneys will have some questions for you. There aren't any right or wrong answers to these questions. The questions are designed to try and determine whether or not you could do your job as a juror in this type of case. So the only correct answer to any of these questions is the truth. Just tell us what you actually think and believe, all right?
No problem.
So let me start with, I don't have any notes indicating that you've ever heard about this case prior to coming to this courtroom.
Correct.
All right. Do you have a personal position or belief about the death penalty?
Honestly, I would need more information to be able to make that type of decision.
That is the law, so you're fine so far. So let me ask you some more specific questions. First-degree murder, as I told you, is the intentional killing of another person. You have no legal justification for it. It's not self-defense. You don't have any other defense. You just murdered someone. And the state has proven it beyond a reasonable doubt. That's the first thing that has to happen before a death penalty conversation even occurs, all right? So a jury's convicted someone of that. Is the mere fact that you've convicted someone of first-degree murder, would that alone result in you voting for death?
No.
All right. If I added to that fact that the person that was killed was a police officer, would that change your answer?
No.
And if I added to that fact that the person was guilty of a prior murder of a pregnant woman, would that change your answer?
No.
All right. You heard me describe the process of the penalty phase. Aggravators, mitigators, weigh them. Number one, could you sit through a penalty phase and listen to everyone with an open mind and process the information you're being given?
Yes.
And is there anything about the process of weighing aggravators and mitigators that you believe you would be unable to do?
No.
If that process led you to believe that the appropriate sentence was life without the possibility of parole, could you vote for that?
Yes.
And if it led you to believe death was the appropriate sentence, could you vote for that?
Yes.
Do you have any doubts about any of that?
No.
All right, moving on to the insanity defense. As I told you, it's been raised by the defense. It's their burden to prove it, and it's in the first phase of the case, guilt phase, where you're trying to decide whether or not he's guilty. If at the end of the guilt phase, you've heard all the state's evidence, you've heard all the defense evidence, you were convinced that he was insane at the time this occurred, would you be able to return a verdict of not guilty by reason of insanity?
Potentially.
All right, what do you mean by potentially?
I would have to hear all the facts of that to be able to make that decision.
Oh, I'm not asking you to vote right now. I'm saying assume you've heard all the evidence and you're convinced by it. Would you be able to vote not guilty by reason of insanity? You haven't heard anything right now, okay?
I know. I'm just a very factual person, so it's to make an assumption to say yes to that without knowing all of the evidence to it. But if it was an overwhelming evidence of that, then yes, I could vote
Okay.
not guilty.
And then lastly, as I indicated to you, the murder of Miss Dixon and her unborn child cannot be used by you to decide whether or not Mr. Loyd's guilty of these charges. It's two separate cases. Can you put that out of your mind during guilt phase?
Yes.
Right. You can use it during the penalty phase as directed, but not during guilt, and you're comfortable with that?
Yes.
All right, thank you, ma'am. I have no further questions for you, but the attorneys do. Mr. Williams, you may inquire.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
You have this pained look on your face. It's just try, like the judge said, just try to relax as best you can. And
Oh, it's the mask deal.
Oh.
It's just uncomfortable.
that explains the pain. Do you have some concern generally about the insanity defense? I'm asking because of the nature of your response. So let me give you an example. There are those in our community who think that insanity, as far as defending against a crime, is always an excuse, and that it's very rarely, if ever, actually true. Do you feel that way?
I think mental health is a problem in our society right now that's been overlooked. So I'm not saying that it's not possible.
Okay. But it would be, are you saying that it's difficult for you to fairly consider it? Because and again, I'm reading it, and if I'm wrong, I want you to correct me. In one breath, you're saying you believe that mental illness is real and it's overlooked, but it seems like you're struggling with the willingness to accept an insanity defense if it were proven to you.
If it's proven to me beyond a reasonable doubt, then yes.
That's not the standard, though.
Okay.
The standard that we have, our burden for everything, is beyond a reasonable doubt. They have to prove it by clear and convincing evidence, which is a lower standard. All right? And there's a lengthy definition of clear and convincing evidence, which is why I'm not giving it to you right now. But I can tell you that it's lower than beyond a reasonable doubt.
Okay.
So what I'm just wondering is there something about the defense of insanity that makes you skeptical? Maybe that's the word, that makes you skeptical of it. And there's no wrong answer.
Oh, no, I understand that. No, I mean, if it's clearly proven to me, then I could.
You could find him not guilty of every reason of insanity?
Yes.
Okay. All right. Was there anything about the court's explanation regarding the process for a decision in a capital case that was unclear to you or that you didn't understand?
No.
Do you feel comfortable that you know what your role is or would be if you were selected as a juror when it comes to rendering a verdict on the sentence in the case?
Yes.
All right. My review of your information indicates that the information you filled out indicates that you were a juror in the past. Is that right?
Correct.
How many times?
Once.
Okay, and how long ago was that?
Oh gosh, I was probably in my mid-20s.
I never, ever speculate on a woman's age. So was that a long time ago for you?
I think like 15, 16 years ago.
Okay.
It was when I was still a resident of Osceola County, so it was so long ago I couldn't tell you the year, but I want to say it was early to mid-20s.
Do you remember the nature of it? Was it a criminal charge or was it civil?
DUI was criminal, correct?
It is? Yes, ma'am. Without telling me what the verdict was, did you reach a verdict?
Yes, we reached a verdict.
All right, and were you the foreperson of the jury?
I can't remember if I was or wasn't. It was so long ago. It was
That's okay.
16 years ago, but we did reach a verdict.
Was there anything about that experience, I almost asked if it was memorable because it sounds like it wasn't, but was there anything about that experience that makes you either want to participate as a juror in this case or dissuade you from wanting to participate?
Neither. I mean, I would accept being a juror. I think it's an interesting process. I'm very much a rule follower, so I like that things are typically clear in how to make the decision. What I do for a living, I look at a lot of information and data, and I look at reoccurring themes to help companies create strategic plans.
Okay, and that dovetails into you're a factual person.
Right.
Analysis.
There's no right or wrong. I look at, show me the data.
So if one, regarding your participation as a juror in this case, because this is obviously very different than a DUI, if one is you can't wait to get out of here and do anything but this, and 10 is you can't wait to see your hotel room when you're sequestered, where do you fall on a 1 to 10 scale as to whether you want to be a juror in this case?
I'm sorry, one was, yes, I want to be a juror.
One is you don't want to be a part of this, you can't wait to get out of here. And 10 is the other extreme.
I would say an 8.
8. And is that based on your interest in it or something else?
It's the interest in law and understanding how this process works and understanding that, you're innocent until proven guilty.
Okay. Now, you said that you, a couple times now, relating to your employment, that you're a factual person, you want to see the data, right?
Yes.
Now, the key to any juror's participation in this process so that it's fair is that you see the data before you render a decision, which makes sense to most people, but I want to make sure you're on board. Yes?
Yes.
Specifically, the way the process works in sequence is we would present the evidence of those aggravating factors the judge talked about, and then you would listen to or consider the mitigating circumstances, which is anything about Mr. Loyd's life, background, or character that they believe is a reason for a life sentence without the possibility of parole. The question I have for you, one of the last questions is, could you give meaningful consideration to anything that is presented to you, even if it's something that at the end of the decision-making process you believe is not that weighty or important? Could you meaningfully consider it?
Yes.
All right. Any concerns about your ability to do that?
No.
Is there anything in your life experiences or background that we have not discussed and that you've not told the judge that you think we should know about you, given that we're trying to select the most fair, impartial jury for this case? I don't know that there is, but by way of example, sometimes I ask that question and people say, my loved one was the victim of a homicide 20 years ago and it shaped who I am, or anything like that you can think of.
No.
Usually if there is, it comes to people's mind pretty quick, so that's fair. Thank you very much for your time.
You're welcome.
Thank you, Honor.
No, you may inquire.
Hello.
Hi, how are you?
Oh, I'm great. How are you?
Doing all right, considering.
Yeah, given the circumstances. You work for Correct Craft, correct?
Yes, ma'am.
Correct Craft? That's the boating company, correct?
Correct.
Okay, I just wanted to make sure I understood what the company was. I want to talk to you a little bit more about the insanity defense, okay? Some of the things you said, when the judge asked if you'd be able to find somebody not guilty by reason of insanity, and we're talking about this case, and so it is the murder of a law enforcement officer. And initially you said to the judge if there was overwhelming evidence. Do you remember saying that?
Yes.
And then to Mr. Williams, you said such things as, I'm not saying it's not possible, right? And you guys had the conversation about beyond a reasonable doubt or clear and convincing evidence.
Yep.
And then you ended with it by saying if it was clearly proven to you, right?
Yes.
Okay. So this is tough, and I know there's a lot of burdens, right? So the state, in proving somebody guilty, has to prove that person guilty beyond and to the exclusion of all reasonable doubt.
Okay.
It is really the highest burden you would ever hear as a juror in this courtroom, okay? Clear and convincing evidence is a much lesser standard, and that's to find somebody not guilty even of the crime of murder of a law enforcement officer.
Okay.
All right, and if we're talking not guilty by reason of insanity, we're talking not guilty. And I get that you're a factual person, but I am genuinely asking about your feelings, understanding there's no right or wrong answer, and the only oath you've taken thus far is to tell the truth. So in finding somebody not guilty by reason of insanity, do you think you'd want to have no doubt in making that determination?
Can I have?
Well, and that's where I get that it's confusing, right? But it's, I don't want to like undersell it, but it's almost more likely than not likely. And so this is beyond a reasonable doubt. Clear evidence is down here. And some people say, yep, that's fine. And some people, and again, no right or wrong answers, say if we're talking about finding somebody not guilty by reason of insanity to the crime of murder of a law enforcement officer, I'm going to want to have no doubt that he was insane or very little doubt. But it's going to be a whole lot more than clear and convincing evidence. Does that make sense?
Yes, so you're asking me if I dream of needing it to be clear, or if I can go to a lower level of clear and concise, correct?
Yep, clear and convincing. Yes, ma'am.
Yes, I could make the decision on clear and convincing.
Tell me how you got from your initial answers, which were a couple, kind of lending us up here, to this.
I think it's just a hard thing to answer, and
Sure.
from the standpoint of, we know this is a murder trial, right?
Yep.
He had stated, prosecution had stated, that most people think that pleading insanity is the most common thing in a murder trial. So it goes back to me without hearing and understanding. Like, I remember the witness list, very well. There's a lot of doctors on there. I'm a very pro-science person. So I think hearing that and understanding, and having friends that I have who've dealt with children who have mental health issues and stuff, yes, I can be clear and I can make a decision on clear and concise. I think it was either one way or the other way, not understanding that their side's reasonable doubt, yours is a little bit lower level. So I think the more that you explained it, the more that I've had time to understand it and process it.
Yep.
Makes me understand, okay.
And that's totally fair. That's why I just wanted to ask you some follow-up questions.
No, that's fine. I appreciate you trying to understand the clarity and, me processing that question.
It's a lot. There is this conception that anybody charged with a serious crime, and this isn't true, but I think a lot of folks think everybody charged with murder pleads not guilty by reason of insanity. Right? Oh, it's just an excuse. It's just a cop-out for somebody who got caught for murder. Do you follow?
Yes.
Is that how you feel?
I think that's the given norm in the society when it's done. So I think that kind of shapes my thought on it off the bat. But would I be able to give a fair and equal trial to someone that was doing that? Yes, I would.
Okay. Why do you... And again, it's totally fair. Your opinion on this isn't the first time I've heard it, I promise. Why do you think you could put aside sort of those norms, societal norms that you talk?
Because this is the court of law, and what we are here to listen to the evidence and listen to everything through that and make that decision. Not what's influenced by the outside, not what's influenced by our emotions, but by looking at everything that's given to us on both sides and making the right decision.
Sure. You can appreciate everybody who comes into this courtroom, lawyer, police officer, juror, comes in this courtroom shaped by their own personal life experiences, walks of life, right?
Right.
And that's okay. And so I'm not asking you to do something that's impossible, right? And some people say that they can do this easier than others. It's about finding folks that are the right fit for this case. And it's not like a value judgment on anybody. Does that make sense?
No, I understand that.
And so now I want to talk a little bit about, because you said you wanted to apply the law and you weren't like a feelings person, so to speak, talking about the death penalty, understanding that in order for us to get to the part where we're considering the death penalty, you have found somebody guilty of the intentional, premeditated killing of an innocent victim. Defendant thought about it, meant to do it, and did it. Right? And in this case, it's a law enforcement officer. And so some folks say, if I make that determination that somebody is guilty beyond a reasonable doubt, no legal justification, excuse, or defense of the murder of a law enforcement officer, I really know for me, my feelings, that death is the only appropriate penalty for that person. Does that make sense?
Yes.
How do you feel?
The death penalty is definitely an option, but I would weigh very heavily on that and hearing the other side of that. If there was a clear, if it clearly was insanity, then I could go back to the other sentence, but I'm not going to make that decision until going through and we determine if they're even convicted of first-degree murder. But that can't even be an option until the guilt part is done.
Right. And let me be clear too, if you find somebody not guilty by reason of insanity, again, it's not guilty. We're not going to be talking about penalty. Does that make sense?
Yes.
And so there could still be mental health issues going on that you could consider in the second part as to what the appropriate penalty is, even if you reject the defense of insanity. Does that make sense?
Yes.
Like I said, a little bit. So insanity is this narrow legal definition that the judge is going to give you. And you may hear about somebody having mental illness, disease, infirmity, or defect, and say, okay, that doesn't meet the definition, the legal definition of insanity, so I'm going to find this person guilty. But you can still consider those mental health issues in deciding what the appropriate penalty is, life or death. Does that make sense?
Yes.
Okay. Do you think you could consider the effects of racism on the defendant who committed the intentional premeditated murder of a law enforcement? And when I say that, I'm talking about meaningfully consider in a way that you're going to hear it, internalize it, and it could possibly impact your verdict as to life or death, not just hear it and dismiss it sort of simultaneously. Does that make sense? No, you're looking at me looking
Are
great.
you, let me clarify, help
Sure.
me understand if I'm understanding. Are you asking me if I will make a decision based on racism?
No, let me clarify it a little bit.
Okay.
So we talk about mitigating circumstances. We're in the second part of this trial now. You found somebody guilty. We're talking about whether life or death is the appropriate penalty.
Okay.
With me?
Yep.
And you may hear, mitigating circumstances can be absolutely anything from the defendant's character, background, experiences, or even from the case itself. It's fairly unlimited. With me? And so you might hear evidence, if we get to the second part of the trial, about the defendant experiencing the effects of racism. And so I'm asking you if you think you could meaningfully consider that in a way that it could potentially impact your verdict as to life or death, knowing we're still talking about the premeditated murder of a law enforcement officer.
Yes.
Okay. Any hesitation or doubt about that?
No.
Okay. You will be probably not surprised to hear me say that folks have differences of opinions on these sort of things.
I understand.
Okay? And the law totally allows that. And that's why the judge has said this, and I'm going to repeat it, that death is never required, not in any case, not in the worst conceivable case you can imagine. Okay? And so if we're in the second part of this trial, where you're deciding what the appropriate penalty is, the steps are, has the state proven the existence of at least one aggravating factor beyond a reasonable doubt? Is that aggravating factor sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? And the last question is death the appropriate penalty? The answer to that last question is never required to be yes, even if all of the other answers are yes. So if you say, yes, they've proven an aggravator, yes, it's sufficient to warrant the death penalty, yes, the aggravation outweighs the mitigation, you can still vote for life. Make sense?
Yes.
If one juror says that life should be the verdict, then life will be the verdict. Follow me?
Yes.
Because all 12 folks would have to be unanimous.
For the death penalty.
Yep. So if one person, if it's 1 to 11, that's still a life verdict.
Okay.
Okay with that?
Yes.
Mitigation can be absolutely, well, no, let me say this. Mitigation does not have to be unanimous. It can be unique to each individual juror. And again, it can be something seemingly small, a smile between the defendant and a family member. And for a juror, that juror says, I assign the weight of life to that, and I'm not imposing a death penalty in this case. And that's okay. You okay with that?
Yes.
In order for a just verdict to be returned in this case, all 12 individual moral assessments about whether Mr. Loyd lives or dies have to be heard in this courtroom. That's your duty, your right, and your responsibility as a juror. With me?
Yes.
And so if you're selected as a juror, when you're deliberating, you'll pick a foreperson. In the penalty phase portion, the foreperson writes down the verdict on the verdict form, but really in doing so, that foreperson is saying, this reflects all 12 individual moral assessments of each juror on this jury. With me?
Yes.
You're not going to allow anybody to bully or badger you into changing your opinion once you've reached that individual moral assessment, right?
Correct.
And you're not going to do that to anybody else.
Correct.
May I have just a moment, Your Honor?
Yes, ma'am. Let me see the attorneys at the bench. We'll be right with you, ma'am. You can put the mic down for now. All right, ma'am. We appreciate your time. We appreciate your willingness to serve. I'm going to excuse you from this jury. You're free to go. Thank you. Juror in seat 56, panel 8. This is juror 217. And this is, as far as my notes go, the last remaining juror from this panel. Okay. Good afternoon, sir. How are you?
I'm good. How you doing?
I'm doing all right. I have a few questions for you, and then the lawyers are probably going to have some questions for you. There aren't any right or wrong answers to the questions you're being asked. The questions are being asked in order to see if we can determine, you switch, and to see if we can determine whether or not you can do your job as a juror. It's something we need to know, and something you need to know, whether you can do this, all right? So the only correct answer is the truth. Let me start with confirming that you've never heard anything about this case. Is that correct?
That is correct.
And do you have any position on the death penalty?
That's a difficult question to answer in a short amount of time that we have. The reason why I didn't pick up my panel, the initial question, was because I actually needed some time to think about this. And the way to answer that I can fully answer is in a spectrum. I will be leaning towards the fact that all life is precious, and I think that there may be only one entity that can decide between life or death, in my opinion, and that's probably God. So it'll be very difficult for me to be put in a position to make that decision unless I really had to.
Okay. Let me break that down a little bit,
Sure.
all right? So is this a personal, moral, or religious belief?
Religious.
All right, what religion are you?
I'm Catholic.
Okay.
I'm Catholic.
And the Catholic Church teaches...
That all life is precious.
Okay, and that the death penalty is wrong. Is that the official
Yes.
position of the Catholic Church? All right. So, in these cases, death is never required. I mean, no juror is required to vote for death. But you have to be able to fairly consider a death sentence. And if the evidence, the facts, and your personal beliefs led you to believe that a death sentence was the appropriate one, you have to have the ability to at least consider voting for it, okay? Again, no one's going to tell you you must vote for death if these things happen. It doesn't work that way. But you have to be able to consider it. Both sides have to have a fair shot, basically, all right? So you're the only person who knows yourself and knows the answer to this. You've convicted someone of first-degree murder to even get to this, to get to a penalty phase, as I told you. The state's putting on evidence of aggravators, the reasons they believe death is the appropriate sentence. The defense is putting on evidence of mitigators, the reasons they believe life without parole is the appropriate sentence. You've got to be able to listen to both of them with an open mind and be open to and process the information that they're giving you. You cannot be sitting in the jury box. An open mind doesn't mean you're sitting in the jury box saying, okay, I'll listen, I'll take notes, I'll do everything you're telling me to do, and then I'm going to go back in there and vote for either life or death, because it doesn't matter what anybody says. You follow me?
Yeah.
So once all that's happened, you're going to go back in that jury room. You've got to weigh the aggravators and the mitigators. So I know you've never been in this position, so to the extent that you can, imagine yourself in this position. You've listened to all the evidence. You're back in the jury room. You've gone through it all. You've weighed the aggravators. You've weighed the mitigators. I've given you the law, the jury instructions. After all that process, you believe life without parole is the appropriate sentence. Would you have any trouble voting for that?
No.
All right. How about if you believe the appropriate sentence was death? Could you vote for death?
No.
Okay. Thank you, sir. State.
State moves.
Defense. You may.
Hello.
Hi.
When the judge first asked you about could you impose a death sentence, correct me if I'm wrong, you said probably not unless I really had to.
It would be almost a forceful had to. So I personally would almost feel like as I'm being coerced to do it.
Okay.
It'd be very difficult for me to decide out of my own willing and have it on my conscience to decide between life or death.
Okay. Here's the thing. It shouldn't be easy, right? I mean, I think that would be probably more disturbing if somebody came in and was like, no problem, right?
Correct.
And so what the law requires for you to be able to serve on this jury is to be able to give meaningful consideration to both possible penalties for first-degree murder. Life without the possibility of parole and the death penalty. And when I say meaningfully consider, I don't mean, like the judge said, I heard it, I kind of dismissed the possibility simultaneously of the death penalty, I'm just going to vote for life. It's I'm meaningfully considering it, that I could see myself potentially, knowing I'm not required, doing one or the other. Do you think you could give meaningful consideration to both possible penalties?
No.
Nothing further, and no objection.
Thank you. All right, thank you, sir. You're free to go.
you,
We
ma'am.
appreciate you being here today.
Oh, anytime.
Thanks. All right. That concludes panel 8. Panel 9. All right, let me see. I show the juror in seat number 9, juror 176. All right, this gentleman is the gentleman who indicated, we're also going to switch out court reporters. This gentleman is the gentleman who indicated he has some hearing difficulties, so if the attorneys need to remove their masks to question him, please do so. Juror in seat number 9, 176, he's not here yet? Bring him up, please. I'm not going to call him into the courtroom because I haven't instructed him to get him up here because we don't have that many people left. So we're going to do juror in seat number 25, then juror 106. And I'm going to stop talking so the court reporters can, are you switching? Not yet? Okay. All right. Yes, ma'am. He said it helps if people have, if the witnesses had clear masks on, because lip reading assists him in addition to being able to hear. He's lost hearing in one ear. I think it's the right one. I'm pointing to my left, but I think it's the right, and he has to turn his head.
Does the court have any consideration as to what you would do about the lawyers? So knowing that like none of us are wearing clear masks.
Yeah, I just said, I know it's a dead zone over there where you could barely hear we can't hear you.
No,
and you
I
can't
heard
hear.
that. I meant for trial. Like when we're questioning witnesses.
Yes, and I would solve that problem, but
Okay.
not right this second. Okay? Thank you. What happened to 25? They're the late ones? Well, I forgot who the late ones are. All right, 9, 25, and 37 were late. All right. So give me seat 29. Just give me someone, anyone. So I have 2 back there, 29 and 30. Okay. Wait, I have 3 back there because I have someone from panel 10. Dear God. Good afternoon, sir. How are you?
Doing good.
Are you juror number 849?
Yes, ma'am.
Okay. Give me 1 second to find this. All right, sir. I'm going to be asking you some questions. There aren't any right or wrong answers to the questions I'm going to ask you. The questions are meant to determine whether or not you are able to do your job as a juror in this type of case. It's something we need to know, and frankly, it's something that you need to know. So the only correct answer is the truth. You with me?
Understood.
All right. So let me start by asking you, you didn't indicate that you know anything about this case. Is that correct?
That is correct.
All right. And do you have an opinion about the death penalty or thoughts about it?
I'm personally a little conflicted, but if it is within the means, then it is within means.
Okay. When you say if it's within means, can you tell me what you mean by that, please?
If everything points to it, then it will most likely have to be the case.
All right. In order to do your job as a juror in cases like this, you have to be able to do certain things. So let's go over this in a little bit more detail than what I did before. Let me start with the first thing that has to happen in any case like this is there has to be a conviction for first-degree murder, meaning the jury has to have found someone guilty beyond a reasonable doubt of intentionally killing another person with no legal basis for it. There's, it's not self-defense, it's not insanity, there's no defense to this. You understand that?
Understood.
All right, so that's step one. Excuse me one second. So, now you're in a penalty phase, right? So let me start by asking you some questions. All that's happened at this point, these are all hypotheticals, all that's happened at this point is you've convicted someone of first-degree murder. Is there anything about that that would cause you to vote for death, hearing nothing else?
Hearing nothing else?
Yes.
No.
Is the fact, if I added that the fact is that it's a police officer who was killed, is there anything about that that would cause you to vote for death, hearing nothing else?
No.
If I add to that there's a previous conviction for the murder of a pregnant woman, would that change your answer?
Yes.
All right. What would your answer be then?
That it would probably be a bit more deserved.
It would what?
It would be more likely.
It would sway you towards death, but would
Yes.
you automatically vote for death just based on that?
No.
All right. After a conviction comes the penalty phase. All right, so now pretend you're in a penalty phase. State's going to put on evidence of aggravators. Defense is going to put on evidence of mitigators. Remember, the aggravators are reasons to vote for death. Mitigators are reasons to vote for life without parole. You have to sit in that chair with an open mind, and an open mind means you're listening to the evidence, you're processing it, you're considering it. Doesn't mean that you have to accept all of it, but you're listening, you're processing and considering. Now you're going back into the jury room to both sides, fairly and openly. You don't stop listening until all the evidence is in. Can you do that?
Potentially, yes.
All right, now you're going back into the jury
Potentially,
room.
yes.
You're going to weigh, I'm going to give you the law, the jury instructions. You're going to weigh those aggravators and those mitigators as I explained to you. At the end of that process, you personally have reached the conclusion that the appropriate sentence is life without the possibility of parole. Can you vote for that?
I'm sorry?
Can you vote for life without the possibility of parole?
Potentially, if the evidence leads to, if the mitigators mitigate the aggravators.
Okay. And if after that whole process you believe the appropriate sentence was death, can you vote for that?
If the aggravators outweigh the mitigators, yes.
Okay. Any doubt in your mind about your ability to go through any portion of that process?
No.
The insanity defense. As I told you, Mr. Loyd has raised that. It is the defense's burden to prove it in the guilt phase when you're trying to determine whether or not he's guilty. If at the end of all the evidence, the state's evidence, the defense's evidence, it's the end of the guilt phase, you believe the defense has convinced you that Mr. Loyd was insane at the time, would you be able to return a verdict of not guilty by reason of insanity?
If they could prove that.
Okay. And then lastly, the murder of Miss Dixon and her unborn child, you cannot consider that in determining whether or not he's guilty of these charges. Do you understand that?
Yes, ma'am.
Can you put that out of your mind when you're trying to decide whether he's guilty or not?
During the guilty phase, of course.
Okay. You can consider it during penalty, but not during guilt. And you're okay with that? All right, thank you, sir. I don't have any other questions for you. The state probably does. Mr. Buxman, you may inquire.
Good afternoon, sir.
Good afternoon.
I want to start by asking you a few questions about the insanity issue. That's an issue that's going to be addressed in the guilt phase of the trial. Part of the trial is to determine whether or not the defendant committed these crimes.
Correct.
Because insanity involves potential mental health issues, I'm going to just ask you a couple personal questions about whether you or a close friend or family member has ever dealt with or experienced mental health issues.
That is fair. Yes.
I'm sorry, I didn't hear you.
Yes, sir.
Okay. Close friend, family member, I'm not looking for names, just relationships.
Few friends.
A friend?
Few friends, yes.
Okay. Were you present with that person while they were going through whatever issues it was?
Yes, sir.
Did that person get help, treatment of some form?
Yes, they had medication.
Yeah, speak up a little bit for the court.
They had medication.
Okay. Based on that, I'm gathering that you are one of the people in the world that realizes mental health is actually a real thing in some people in society.
Yes, sir.
Okay, because some people don't think like that, but you're not one of those people, correct?
No, sir.
All right. Would you be able to listen to all of the evidence relating to whether there is a mental health issue in this case? And if so, what the effects or ramifications of that mental health issue is, before you make an ultimate decision of whether or not the defense has proven to you that insanity is a defense in this case?
I'm sorry, if you could repeat that?
Sure. Basically, can you keep an open mind and wait to listen to all of the evidence regarding whether there's a mental health issue in this case? And if there is, what the consequences of that issue is before you make a final decision?
Yes, sir.
Okay. Shifting gears a little bit to the penalty phase now. For purposes of these questions, we're going to assume that the jury has already determined the defendant is guilty beyond a reasonable doubt of the murder in this case, which means the jury has rejected any defenses, rejected any insanity defense, and found him guilty. Okay? The focus of these questions is basically to determine whether or not you can keep an open mind and listen to all of the evidence. The state will present evidence of aggravating factors, and the judge alluded to a couple of them already. And aggravating factors are just those factors that make this murder more egregious or worse than other murders. So we've talked about the fact that the victim in this case is a law enforcement officer, which is an aggravating factor in Florida that you could consider, if proven, to lean your decision towards the death penalty. So is the fact that he has been convicted of a prior murder. That's an aggravating factor that you could consider and give weight to determine what the proper sentence is. So my question is, if assuming that you have found, proven to you beyond a reasonable doubt that the victim was a law enforcement officer and that he committed a prior murder, those things might tend to start your pendulum swinging towards the death side of the proper sentence.
Yes,
Make
sir.
sense? No matter how far that pendulum swings, with all the aggravating factors and all the evidence pertaining to them, could you always wait and listen to the mitigating evidence presented by the defense? Evidence about the defendant's background and upbringing and things like that before you make a final decision in this case?
Yes, sir.
Okay. Can you do that regardless of what piece of evidence or what mitigation is presented to you? Could you consider it all no matter what it is?
Yes, sir.
Okay. Even if this is not the time to talk about the details or the actual pieces of evidence that you're going to hear, that's during the trial. So even if at first blush you're told about something that could potentially be a mitigator, and in your first thought is, I don't think that's mitigating, can you hold off judgment until you hear the details surrounding it and the evidence about it?
Yes, sir.
Okay. Once you hear that evidence, then you're going you go through the process of weighing the aggravating factors and mitigating circumstances to determine what the proper punishment in this case should be. When you first started talking with the judge, you said that you were conflicted about the death penalty.
Yes, sir.
Can you explain to me a little bit about what you meant?
I'm a little conflicted because I don't exactly know how I feel about voting for a man to potentially be executed.
Okay.
I don't know how to weigh upon myself.
Okay.
I've never had that experience before.
Sure. So obviously it's a heavy,
Yes.
weighty thing to consider and to be involved in. Sure. Let me follow up on that a little bit. If after well, first of all, the judge indicated that there's nothing that will ever require you to vote for the death penalty in this case.
Correct.
You're not going to be in a position where if you check these 5 boxes, then you have to vote for the death penalty. That make sense?
Yes, sir.
It's going to be completely up to you and the other individual jurors what your opinion of the proper punishment should be in this case. If you find yourself back in that jury room, and after you've done this weighing process and considered all of the evidence, you felt that the life in prison was the proper punishment, could you vote for that?
If I found it to be the proper punishment, then yes, I could vote for that.
Okay. On the flip side of the coin, if you're back there, and we're not talking a hypothetical situation where you're hanging out with friends and talking about the death penalty and saying, yeah, I could vote for death on that person. We're talking a real life situation. If you found yourself back there, you've weighed all the evidence, you've mulled it all over, and you in your heart have determined that the death penalty is the proper punishment in this case. Knowing that you're never required to vote for death, would you be able to raise your hand and say, I believe that this man deserves to die for what he did?
Overruled.
Only you know that question. That's something you have to look deep inside yourself to see if you think you could do that. I'm going to give you a second. I'm going to check my notes real quick, okay?
If the jury in the deliberation room has decided that we've all unanimously decided that the proper punishment is death, then yes, I could vote for that.
Okay. Now you said if the jury decided it. Remember, this is your individual decision. Not
Not
the
the
rest of
jury.
the jurors say. This is all in you.
If everything points, if the aggravators are more heinous than the mitigators, then yes, I could potentially vote for death.
Okay. Any concern, any doubt in your mind, you could do it if you felt that was the right decision?
Yes.
Okay. Is there anything in your background, your life, your experiences, your belief system that may make you think I might not be a good juror for this type of a case? I'm not saying there is, I'm just asking.
Inexperience, but that's about it, honestly.
You experienced what?
Inexperience.
Inexperience, okay. Well, I can probably assure you that no one else has ever been in this situation either. So, you're doing fine. I have one moment, Your Honor.
Yes, sir.
Thank you, sir. No further questions, Your Honor.
Thank you, Mr. Buckley. You know where your name for?
Hello.
Hello.
How are you?
Doing good.
You've taken an oath to answer truthfully, so you had to think about that one. I want to just ask you a couple clarifying questions, okay?
Of course.
So in order for us to even be talking about possible penalties for first-degree murder, life without the possibility of parole, or the death penalty, a defendant would have to be found guilty, right? The judge asked you some of these questions.
Correct.
And so the crime of first-degree murder is the intentional, premeditated killing of an innocent victim. The defendant thought about it, he meant to do it, and he did it.
Correct.
And if a jury found that person guilty, that jury would have rejected or eliminated any defense available to that person. With me?
Yes.
So we're talking about premeditated intentional murder without any legal justification, excuse, or defense. And when the judge asked you, you initially said death would not be the automatic or only penalty for you for someone guilty of that crime. Is that correct?
Correct.
Okay. You can appreciate some people think that if you've committed the crime of premeditated intentionally killing somebody, the only penalty is really the death penalty. With me?
Yes, ma'am.
Does that make sense? That people have differing opinions on this.
Absolutely.
And then the judge asked you about law enforcement. If the victim was a law enforcement officer, would death, and we're talking about the intentional premeditated killing of a law enforcement officer without legal justification, excuse, or defense, would the death penalty be the only appropriate penalty for that person?
No.
Okay. And then here's where I have some confusion, because when the judge asked you about if that defendant, same circumstances, had been previously convicted of the murder of a pregnant woman, your answer was yes. Do you remember saying that?
Yes, ma'am.
What were you saying yes to?
It was more or less because he murdered someone else before. It wasn't the first time.
Right.
So I think that's more egregious.
Yep. And I think that's fair. I think a lot of people feel that. The question is death the only appropriate penalty for somebody who commits the second murder, who's been previously convicted of another murder and is serving life without the possibility of parole? Does that make sense? Like, I'm asking if you could still consider life as a penalty for this second murder, knowing he's already doing life.
It'd be a bit trickier, but it is potential that I could think about it.
Okay, so correct me if I'm wrong, you said it would be a bit trickier.
Yes, it would weigh a bit more heavier on me. I would lean more one way than the other.
Okay, and again, the aggravators are intended to do that. The mitigators are intended to bring you back towards life.
Right.
So the question isn't, would it make you lean more towards death? It's, is death the only choice? Do you understand the distinction?
Yes.
If you could give me that answer.
Yes, no. It would not be the only choice.
Okay. And let me clarify one thing too. So if we're in the second part of this trial, right, we only get to this penalty phase if the state has proven Mr. Loyd guilty beyond a reasonable doubt of the crime of first-degree murder, or if we have failed to prove that he's not guilty by reason of insanity. If either of those things, if they fail to prove him guilty or we succeed in proving him not guilty, we're done. He's not guilty, right?
Correct.
So if we're in the second part of that trial and we're talking about penalty, with me? The steps are, in this penalty, has the state proven the existence of at least one aggravating factor beyond a reasonable doubt? Is the aggravator sufficient to warrant death? Do the aggravating factors outweigh the mitigating circumstances? And then the last question is death the appropriate penalty? And that last question is never required to be yes, even if all the other answers are yes. So you could say, yes, they proved an aggravator. Yes, it's sufficient to warrant the death penalty. Yes, the aggravators definitely outweigh the mitigators, but I'm still not voting for death in this case. Does that make sense?
It does.
Because you had said before, when you were talking about could you vote for life or death, you were like, yes, I could vote for life if the mitigators outweighed the aggravators.
Correct.
Remember? And you said I could vote for death if the aggravation outweighed the mitigation.
Correct.
Okay, and that's the law. The question is, could you still contemplate a life sentence even if the aggravation outweighed the mitigation?
It would depend on the weight of the aggravators and the weight of the mitigators.
Okay. You get to decide as a juror what weight you assign to any factor, aggravating or mitigating.
Correct.
And that's where it is an individual moral assessment. I do agree with Mr. Buxman. This one's on you. With me?
Yes, ma'am.
And so some of the aggravators are huge. It's the murder of a law enforcement officer, a prior conviction for murder of a pregnant woman. And the mitigation can be something like the effects of racism on the defendant. Do you think you could give meaningful consideration to something like the effects of racism on the defendant, given the totality of the circumstances? And when I say meaningful consideration, I don't mean I heard it and I kind of dismissed it as I heard it.
I'd have to hear all the evidence.
Okay, but is that something you could give meaningful consideration to?
Yes.
Okay. Just to reiterate a couple of the points that you've already heard, death is not required. With me? Not in any case, not in the worst imaginable case you can conceive of. If one juror votes for life, then the verdict will be life. Right? The law gives tremendous power to the individual juror. With me? You have to say it out loud.
Yes, ma'am.
Okay. Mitigation, as we've already discussed, is just why any one juror would choose life or not choose death. It can be unique to each individual juror, and it can be, on its face, seemingly small, and still a juror can assign the weight of life to it. As an example, a juror could say, I observed a smile between the defendant and a family member, and I'm giving that the weight of life, and I'm not voting for the death penalty in this case. Does that make sense?
Yes, ma'am.
You seemed a little hesitant. Tell me what you're thinking,
I was
please.
trying to recap what you said.
Okay, I know, I talk a lot. Sometimes in the deliberation room, things can be contentious. People have strong opinions that often differ on these sort of things. Fair?
Absolutely.
And so what the law requires in order for it to be a just verdict as to penalty, that all 12 jurors' individual moral assessments about whether Mr. Loyd lives or dies have to be heard in this courtroom. That is your duty, your right, and your responsibility. With me?
Yes, ma'am.
It would be a miscarriage of justice if somebody's individual moral assessment on that jury wasn't reflected in the verdict. Does that make sense?
Yes, ma'am.
Okay. And so you are not going to allow anybody to bully or badger you into changing your opinion if you've reached an individual moral assessment.
No, ma'am.
You're certainly not going to bully or badger anybody else to agree with you, right?
No, ma'am.
In fact, if you've reached an individual moral assessment that the verdict should be life, and you don't feel like it's being respected by your fellow jurors, you can be like, we're done. I've reached a verdict. It's life. Deputy, please get the judge. We can go home now. Do you think you can do that?
Yes, ma'am, if I feel that way.
Okay, and so that's what, you're a little bit of a soft-spoken person, but you have to make sure, and here's what's great, too, because we talk about deliberating, right? And we encourage people to hash it out, but you don't have to. If you've reached an individual moral assessment, you can, for life, and you can say, hey, listen, I can't explain it, I can't articulate it, I just know in my gut, in my heart of hearts, that the verdict is life, and that's okay too. Okay? Yes?
Yes, ma'am.
Okay. May I have just a moment, Your Honor?
Yes, ma'am. All right, let me see the attorneys. We'll be right with you, sir. You can relax. All right, sir, we appreciate your time and attention. I'm going to excuse you as a juror in this case. You are free to go. Thank you so much.
Thank you kindly.
We're switching out, or you want to keep going? We switching? You're. All right, we're switching. We can. When you come back, you need to log back into Bridge. Are you Markeith capital or Markeith lowercase? Cap? All right, let's go back on the record on State versus Loyd. He's present with his attorneys. The State Attorney's Office is present. Juror in seat number 30, panel 9. This is juror number 922. Good afternoon.
Good afternoon.
Let me take this off. How are you doing?
Very well, thank you. And you?
I'm fine, thank you, ma'am.
Good.
All right, I'm going to be asking you some questions, and then the attorneys will have some questions for you. There aren't any right or wrong answers to these questions, ma'am. The questions are designed to try and determine whether or not you can do your job as a juror in this type of case. So the only correct answer is the truth, okay? So let me start by confirming that you've never heard anything about this case?
Not until today.
All right. Do you have any thoughts or position on the death penalty?
That's a hard question to answer. I think in some cases it would be warranted, but I would have to have more information on any particular case.
All right, and that is Florida law. You can't just announce, we don't have automatic death penalties,
Right.
so. Let me ask you some specific questions about, again, this is all the death penalty. We'll get to other things in a second. As I told you, in order to get to even considering a death penalty, a jury has to have convicted someone beyond a reasonable doubt of first-degree murder, intentionally killing another person with having no legal reason to do so. It's not self-defense, you're not insane, you just killed someone, and that's first-degree murder. So a jury's convicted someone of that. So is that alone for you enough for you to say, I'm going to vote death?
I would have to know under what circumstances.
Well, that's part of,
Yeah.
when you say under what circumstances, what do you mean by that?
Well, I would have to know more information of what happened, but yes, my answer would be yes.
Okay. So what I'm trying to find out, and do not let me put words in your mouth, all right, is, as I told you, there's a penalty phase that follows a conviction for first-degree murder, and you have to have an open mind during that penalty phase.
Yeah.
You have to be open to, and by open, I mean genuinely open. You're actually listening to everything, you're processing information,
Right.
you're thinking about it and weighing it,
Right.
and you have to be genuinely open to either life without parole or death. So the question that I'm asking you is, if all you have is there's a conviction for first-degree murder, are you someone who's sitting there thinking, I think that alone warrants the death penalty with nothing else? Just that conviction and, of course, whatever facts you heard during that trial?
Yes.
Okay. So if I add to that the person who died was a police officer, would that change your answer, make the answer more firm? Would it have any effect on your answer?
No, they would still be a person.
Okay. And if I added to that the fact that the person had a prior conviction for murder of a pregnant woman, what effect would that have on your answer?
None.
None? Okay.
None.
So do you believe that you could go through the process that I've described of there's a conviction for first-degree murder, Now you're in a penalty phase. You've got to be open to all this information and openly and fairly consider life without the possibility of parole. Do you think you could do that, or would you be someone who would be thinking, I've convicted this person, I'm going to vote for death?
I would keep an open mind during the whole process, and if I felt that I had to, again, I would have to just have more information, but yeah, I would keep an open mind.
Okay. I think I'm confusing you,
Yeah.
okay? And I'm not trying to, but sometimes I do confuse people without meaning to. So let me try this again. You've convicted someone of first-degree murder, intentionally killing another person.
Okay.
Now there's a penalty phase. If you're sitting in that jury chair and the penalty phase has started, the state's going to put on evidence of aggravators, reasons they believe the death penalty is the appropriate sentence. The defense is going to put on evidence of mitigators, reasons they believe life in prison without parole is the appropriate sentence. Okay? Can you listen to that evidence with an open mind? And by that, I mean, can you listen to it, process it, genuinely be open to what you're hearing in court?
Yes.
All right. And you're going to go back in the jury room with all of that evidence at the end and the instructions on the law by me. You're going to be weighing those aggravators and mitigators, assigning importance to them, as we told you. What's important to you, what isn't? At the end of that process, if you believed that the appropriate sentence was life in prison without the possibility of parole, could you vote for that?
Yes.
And if you believed the appropriate sentence was death, could you vote for that?
Yes.
So would you automatically vote for life or death in a case like this? Or would you, do you understand there's a difference in thinking about things, going through the process, or just saying, if I convict someone of this, I'm voting for death?
I can't, if I felt that I had to do it, I would.
All right. The law in Florida never requires you to vote for death.
Right.
Okay? There's not going to be a single jury instruction that says, if all these things happened, you are required to vote for death. You understand that?
Yes.
You just have to be able to consider both death and life.
Yes.
All right. And you can do that.
Yes.
All right. The insanity defense. Mr. Loyd has raised the insanity defense. The defense has to prove it by clear and convincing evidence. It's a lower standard than reasonable doubt.
Okay.
But if at the end of the guilt phase, this is when you're determining whether he's guilty or not. If at the end of the guilt phase, pretend you were convinced that he was insane, would you be able to vote for not guilty by reason of insanity? All right. And then my last question to you is, I told you that he's previously been convicted of the murder of Miss Dixon and her unborn child. You cannot use that to determine whether or not he's guilty. Can you put that out of your mind during the guilt phase? You can use it during penalty, but not during guilt. All right. Thank you, ma'am. I don't have any other questions. State, you may inquire. Mr. Butler.
Good evening, ma'am.
Hi.
The first couple questions I have deal with the insanity issue. And that is something that the judge indicated is going to be talked about during the first part of the case, the guilt phase, the part of the case that is designed to determine if the defendant is guilty of the crimes. Okay. Because insanity inherently involves a mental health aspects, I'm going to ask a couple personal questions of you, and I hope you don't mind. I apologize. Have either you or a close friend or family member had any experience with mental health issues?
My nephew is schizophrenic.
Okay. Have you been around your nephew while he's been going through those issues?
Yes.
Has he sought treatment or some sort?
Yes.
Has it helped?
Yes.
Would you be able to keep an open mind and listen to all of the evidence surrounding the mental health issues and the insanity defense before you come to a conclusion as to whether or not the defense has proven it to you?
Yes.
Okay. Shifting to the sentencing phase of this. For purposes of these questions, I'm going to ask you to assume that the jury has already found the defendant guilty beyond a reasonable doubt of the first-degree murder crime. The jury has rejected the insanity defense, found it wasn't appropriate, and we're now into a penalty phase, okay? The whole purpose of this phase is to determine whether or not what the proper punishment should be, either life or death. The state will, that this time, this process while we're talking is not the time to discuss the actual pieces of evidence and the details of the aggravating factors and mitigating circumstances. That's for the trial. So we're not going to get into all the specifics of what you may hear if you've selected for this jury. But the state will present evidence of aggravating factors. Those are factors that make this murder more egregious or worse than other murders. Those aggravating factors, after you hear the details of them, may turn out, and if it's proven beyond a reasonable doubt, they may turn out to be very important to you. Could be some importance, could be a lot of importance. But those aggravating factors, after you hear them, may cause the pendulum of your decision-making process to go towards the death penalty. No matter how far it goes towards the death penalty, are you willing and able to listen to any of the mitigation evidence, all of the mitigation evidence that the defense presents?
Yes.
Okay. Are you able to, no matter what piece of mitigation evidence is presented to you, are you able to listen, think about it, look at the evidence that's presented that deals with each of those pieces of evidence, mull it over before you make an ultimate decision on what the proper punishment should be?
Yes.
All right. Can you do that even if at first blush when it's presented to you, you may be thinking, I don't really think that's mitigating? Can you hold off judgment until you hear the actual details?
Yes.
Okay. Once you go through that weighing process, you decide how much importance to give all this different information to you, and it could be different for each juror. You then are going to have to make a decision as far as what the proper punishment should be. And I believe when you were talking to the judge, you said something to the effect of, if you felt the death penalty was the appropriate penalty in this case, you could vote for it if you had to. The judge told you that the law never says you have to vote for the death penalty. Does that make sense?
Yes.
Okay, so when you said if I would vote for it if I had to, kind of walk me through what you were thinking when you said that.
I suppose if I looked at the facts that were presented and also what the law required, and if the facts that were presented met the criteria of what the law stated, then yes, I would.
Okay. The law is never going to tell you that you have to vote for death. You're not going to have a checklist back there and say, if you check off these boxes, then you have to vote for death. It's always going to be your decision.
Okay.
Okay, so it's always going to be your individual decision of what the proper punishment should be. Does that make sense?
Okay, yes.
Knowing that it is always your decision and that you never have to vote for the death penalty. If you find yourself back in the jury room, and I'm talking a real life situation, you're here, not a hypothetical hanging out with friends talking about the death penalty, but you're actually here.
Right.
And the law never requires you to vote for death. Would you be able to raise your hand in that jury room and say, this man, if you find that the evidence and all the facts leads you to believe the death penalty is the proper punishment, could you raise your hand and say, I vote for death, I think this man deserves to die for what he did?
If the evidence and the facts convinced me yes.
Okay. Likewise, if you felt that the evidence and facts convinced you that life was the proper punishment, could you vote for that too?
Yes.
Is there anything in your background, your belief system, your experiences that makes you think maybe I'm not a good juror for this kind of a case? I'm not saying there is, I'm just asking.
Not that I can think of.
Okay. Can I have one moment, Your Honor? Thank you so much for your time, ma'am. No further questions, Your Honor.
Thank you, Mr. Braxton. Ms. Miller?
Hello.
Hi.
I just want to clarify something you said to Judge Marquez, okay? So we're on the same page, because we've never met, so I want to make sure I'm understanding you. Premeditated first-degree murder in Florida is defined as the intentional, premeditated killing of an innocent victim. That defendant thought about it, he meant to do it, and he did it. With me?
Yes.
If a jury found a defendant guilty of that crime, a jury would have considered any defenses available to that person, like the judge talked about, insanity, self-defense. But in finding him guilty of intentionally and in a premeditated design killing someone, that jury would have rejected any of those defenses. And so for you, I'm asking you as a person what your feelings are. Is death the only appropriate penalty for the person that's guilty of that crime?
No.
Why not?
I would have to know the circumstances of what happened.
Okay. And that's sort of almost the exact answer the judge gave you, or you gave the judge, excuse me. And the judge's question was, tell me what you mean by circumstances. I'm asking the exact same thing.
I guess the details of what happened, I don't know any of the details. Before today, I hadn't heard any of this, so I don't really know. I guess in answer to your question, I'm willing to listen to everything before. I can't give you an answer without knowing more information. In other words, I want to listen to what everybody has to say, and then I can answer your question. But yeah, I would either way. I'm trying to keep an open mind, so I can't give you a definitive answer, yes or no.
Okay. And here's where I'm going with this, right? Some people say, I want to follow the judge's laws and the rules, but for me, my feelings, not talking about the law, is that somebody who's guilty of first-degree murder deserves the death penalty, right? So that's where it wouldn't be fair if we didn't know how you felt and you wound up on the jury and you were like, oh man, I really do think everybody who's guilty of murder deserves the death penalty.
No, that's not true. No, not everybody who is guilty of murder deserves the death penalty.
Okay, how about the murder of a police officer? Is everybody who kills a police officer in an intentional, premeditated way without legal justification, excuse, or defense, in that scenario, is death the only appropriate penalty?
No, I don't know, no.
Okay. And Mr. Buxman talked about this when you said, I want to hear from everybody.
Right.
This is an individual moral assessment. This is your call. Nobody else is going to be able to tell you the right answer to a question like, do I think this person should live or die?
Right. Well, you're speaking in absolutes. Does everybody who kills a police officer deserve the death penalty? No, not everybody.
Okay. How about if you hear the defendant has a prior conviction for murder of a pregnant woman and is serving life without the possibility of parole? Now, is death the only appropriate penalty?
No, because that was a prior conviction, and that wouldn't have anything to do with the current case.
And you are doing great at reciting what the judge told you.
Right.
But it's not allowed to have anything to do with your verdict as to guilt, right? Whether or not somebody's guilty of some other crime really has nothing to do with whether or not he's guilty of this crime.
Right.
It does have something to do with what the appropriate penalty is, okay? Does that make sense? Some people say to me, if I know, we're in the second part of the trial,
right,
where you're deciding the penalty,
right,
And if I know, I've just found this person guilty of murder, and I know that he's already serving life
Okay.
for another murder, that really death is the only appropriate penalty. Does that make sense?
Yeah.
How do you feel?
I'd really have to think about it. But I can't say that would be the only. I hate to speak in absolutes. That's the. I don't know. I don't know.
The state asked you some questions about mental health. Do you think mental health is, or people truly suffer from mental illness?
Yes.
I want to ask you about something a little bit, same question, different topic. Do you think racism is real in the sense that it can affect the direction of someone's life?
Yes.
Do you think that you would be able to consider in a meaningful way, think about it, internalize it, and potentially it affect your verdict, the effects of racism on a defendant who is guilty of the intentional premeditated murder of a law enforcement officer?
Would I consider it?
Could you be open to giving that meaningful consideration?
Yeah.
Okay. You would not be surprised, I suspect, to know that folks have differing opinions on these sort of things. Right? Is that a yes?
Yes.
And that's okay. Right? The law, in order for a just verdict to be returned, all 12 jurors' individual moral assessments as to whether Mr. Loyd lives or dies have to be heard in this courtroom.
Yeah.
And so you're not going to bully or badger anybody to agree with you if they have a differing opinion, right?
Right.
And you would not allow anyone to do that to you, correct?
Correct.
May I have just a moment, Your Honor?
Yes, ma'am. Okay. Either side need to approach?
No, Your Honor.
Okay. Ma'am, your juror number's 922, right? Is your juror number 922?
I'm sorry?
Is your juror number 922? Yes. Okay.
Yes.
Sorry. Yes. Ray? All right, ma'am. Let me take this off so you can hear me. We're going to send you through for a final round of questioning. That round, we will be picking the jury that day. It's going to be next week, all right? So you need to call Friday after 5. We're going to give you a packet. It's got a slip of paper in there with a phone number that's going to tell you what number to call. Call that number. You're going to listen for the recording that says the purple dots, because we're changing your color to purple. The purple dots are to report on such and such a date at such and such a time. When you report that day, we will be picking the jury that day and sequestering the jury that day. So you're going to need to have packed a suitcase. If you're picked, leave it in your car. If you're picked, we'll have you go get it. If you're not, obviously you can just go home. There's also a sequestration package in here that explains to you what it's like being sequestered, what the rules are, what to expect, and gives you a list of things that we suggest you pack. All right? There are laundry facilities. Somebody asked me this earlier, so I'm going to tell you there are laundry facilities. So you don't have to pack for 3 weeks, unless you want to, but you only have to pack for a week or so, all right? But all the instructions are in there. And lastly, we have a letter for your employer indicating that you are returning for jury services. But it doesn't give a date because we don't know yet, but it'll be next week, all right? Do you have any questions, ma'am?
No.
All right, thank you so much. Have a good evening.
Thank you. You too.
All right, from panel number 10, the last juror I have who's been instructed is seat number 3, please. And then we have 3 jurors that we'll be returning to in panel 9 who weren't here for the instructions. Whose number? Oh, I haven't said it yet because I've got a dot covering it. Hold on. This is juror number 598. Good afternoon. How are you?
I'm good, and you?
Good, thanks. You are juror number 598, right?
Yes, ma'am.
Okay. We have some questions for you, all right? I'm going to start, and then the lawyers will have some questions. There aren't any right or wrong answers to these questions. There's no pressure. There's no right or wrong answer. The questions are designed to determine whether or not it's for all of us, including you, to figure out whether or not you can do your job in this type of a case, all right?
Yes.
So the only correct answer is the truth.
Yes.
So let's get started. Number 1, I'm confirming that you've never heard anything about this case. Is that correct?
That is correct.
All right. And you work for a law firm in Kissimmee, correct?
For now, yes.
For now?
I will be leaving because the drive is a little much on me.
I understand. That law firm, as I understand it, does not do criminal law. Is that correct?
That is correct. They do real estate, probate, and estate planning.
All right. Do you have any beliefs or position about the death penalty?
Not really.
Okay.
If it's warranted, then it's warranted.
All right. Are you someone who believes the death penalty should be automatically imposed if someone is convicted of first-degree murder?
No, ma'am.
And you know first-degree murder is the premeditated killing of another person with no legal justification for it.
Yes,
okay.
ma'am.
And that's the first thing that has to happen before there's even a discussion about the death penalty being a possibility. Death is never mandatory in the state of Florida. So let me add some facts to conviction on first-degree murder. If that conviction is for the death of a police officer, would you be someone who would automatically vote for death without hearing anything else?
No, I'd have to know what the circumstances were.
All right. And if you were told that there's a prior conviction for the murder of a pregnant woman, would that cause your answer to change?
No, ma'am.
You heard me describe what the process is. The penalty phase, the aggravators, the mitigators. Got to listen with an open mind. Do you think you would be able to listen to both sides with an open mind?
Yes, ma'am.
And do you think you would be able to weigh those aggravators and mitigators as I explained?
Yes, ma'am.
If that led you to believe that the appropriate sentence was life without parole, would you vote for that?
Yes, ma'am.
If it led you to believe that death was the appropriate sentence, would you vote for that?
Yes, ma'am.
Let's switch gears to the insanity defense. Defense has to prove it by clear and convincing evidence. It's a lower standard than the state standard of reasonable doubt. Pretend it's the end of the guilt phase. You're trying to decide whether he's guilty or not. Defense has convinced you he was insane at the time of the offense. Would you return a verdict of not guilty by reason of insanity?
I'm not sure.
Okay, what's causing you to hesitate?
I guess not knowing the full circumstance.
Oh, I'm not asking you to commit to anything.
Yeah.
This is pretending, all right?
Yeah.
We're pretending. So these are hypotheticals, ma'am, all right? You haven't heard anything.
Right.
All right, so I'm asking you to assume that at the end of all the evidence, the defense has put theirs on, the state's put theirs on, but at the end of that evidence, you are convinced by the evidence that he was insane at the time. Would you be able to return a verdict of not guilty by reason of insanity?
Yes.
Okay. Do you have any doubt about that?
No.
All right. And then lastly, as I told you, the murder of Miss Dixon and her unborn child, you can't use that to determine whether he's guilty or not of these charges. That only becomes relevant if we get to a penalty phase. Can you put that out of your mind during a guilt phase?
Yes.
All right. Thank you, ma'am. I don't have any other questions for you. State and defense will. Mr. Buxman, you may inquire.
Thank you. Good evening, ma'am. How long have you worked at that law firm?
Mid-June of this year.
Are you going into the similar field on a different location, or are you switching careers?
Switching careers.
Okay. Couple questions about the insanity issue. You have a really long pause, but I'm assuming that was cleared up when you realized the question was, if you have to listen, can you listen to all the evidence? And if the evidence convinced you the defense had been proven of insanity, could you vote that way? And you could.
Yes.
Understood. Have you or a close friend, family member, somebody close in your life had any experience with mental health issues?
Yes.
Okay. I'm not asking you to tell me a name of a person, but can you give me an idea of the relationship of that person to you?
Close family, sibling.
Were you present while that sibling was going through that mental health issue?
I was very young.
Okay. Do you know if that person has sought treatment, medication, therapy of some sort? Has it helped?
Yes.
Wonderful. Okay. Shifting gears to penalty phase.
Okay.
And these questions are assuming that the jury has already heard the evidence for the first part of the trial, the guilt phase. The jury has determined that the defendant is guilty beyond a reasonable doubt of first-degree murder. They've rejected insanity as a defense, and they found him guilty.
Okay.
Okay? I have a couple questions about the death penalty, or the sentencing process. This is not the time for us to talk about the specific details or what evidence you're going to hear about aggravating factors and mitigating circumstances. That's later. So I'm going to ask you some generalities. You have heard from the judge that the victim in this case was a law enforcement officer.
Yeah.
That is an aggravating factor. You've also heard that the defendant was convicted of a prior murder. That is also an aggravating factor in Florida. Now, you can't use that in the guilt phase to determine if he committed the crime. But assuming you've determined he committed the crime and found him guilty, it may come into play in the sentencing phase.
Okay.
So if you hear all these evidence of these aggravating factors and they're proven to you beyond a reasonable doubt, some of those aggravating factors may start causing your death penalty, your pendulum, to start swinging towards the death penalty because these aggravating factors are, swinging over this direction. My question is, no matter how far these aggravating factors and the evidence swings you over to the death penalty side, can you promise me that you could listen and truly consider any evidence presented by the defense of mitigation before making your final decision?
Yes.
And again, mitigation is just simply evidence that of the defendant's background, of his life, of his character, that could cause you to feel that life is the proper punishment. Okay?
Okay.
So can you assure me that you can listen to the evidence, even if your pendulum is way over here on the death penalty side, you can consider that any mitigating evidence presented to you before you make a decision?
Yes.
Okay. Can you promise me you can do that even if at first blush something is told to you about a piece of mitigation evidence and your first thought is, I don't know if that's mitigation, I don't think that's that qualifies. Can you hold off judgment until you hear the details and all the evidence surrounding it to make your decision?
Yes.
Okay. Once you hear all the evidence of the aggravation and the mitigation in this case, then it comes to your decision of what the proper punishment should be. And that is an individual decision that you and all your other jurors individually have to make. Nothing ever requires you in the law to vote for the death penalty. Okay? You're not going to get a checklist that says if you're back there and you check these boxes off, you must vote for the death penalty. If after considering all the evidence and evaluating it, mulling it over in your mind, you felt that in this case, life in prison is the proper punishment in my heart.
Mm-hmm.
Can you vote for that? Can you vote that life is the punishment?
Yes.
All right. On the flip side, if you find, and not a hypothetical situation, you're hanging out friends and talking in the abstract, real life situation, if you're back there in the jury room and you're deliberating and you find, and you're mulling over all of the evidence and you determine in your heart that the death penalty is the appropriate sentence, can you raise your hand and say, I vote for the death penalty, I vote that this man deserves to die for what he did?
Yes.
Any hesitation in your ability to do that, looking inside yourself?
No.
Is there anything in your life, your background, your belief system that makes you think maybe I'm not a good juror for this type of a case? I'm not saying there is, I'm just asking.
No, sir.
Okay. Thank you so much for your time, ma'am.
You're welcome.
No further questions,
you.
Your Honor.
Ms. Miller, you may inquire.
Hello.
Hi.
Let me ask you first. Do you live in Orange County?
Yes, ma'am.
Okay. Work in Osceola right now?
Correct.
Okay. The insanity defense. I just have a couple clarifying questions.
Okay.
I think you can probably get where we're going, is that we are talking about the intentional, premeditated killing of a law enforcement officer. Defendant thought about it, meant to do it, and did it without any legal justification, excuse, or defense, right? If somebody's found guilty. Okay, so we're considering now if that person has been proven not guilty by reason of insanity, okay?
Okay.
Not guilty by reason of insanity is still not guilty. We don't go to a penalty phase. The person's found not guilty. And so some people think that insanity is a cop-out or an excuse. Have you ever heard anything like that?
Not really.
Okay.
But
do you think you could find somebody not guilty by reason of insanity for the crime of murder of a law enforcement officer?
All right, can you?
Sure. The question is, do you think you could find somebody not guilty by reason of insanity? So that's somebody,
Okay.
let me break that down a little bit. If somebody's saying, I'm not guilty by reason of insanity, that person is saying, I did it. I was just insane at the time, so I'm not legally responsible.
Okay.
Does that make sense?
Yeah.
And so under those circumstances, some people say, for the crime of murder of a law enforcement officer, I would not be able to find that person not guilty by reason of insanity. Does that make sense? How do you feel?
I mean, if it's proven that they were not of the right mind at that time, then yeah, I would go with not guilty.
Okay.
With insanity.
Okay. And you, when the judge asked you about the murder of a police officer specifically, you said it would just depend upon the circumstances.
Correct.
Am I correct in assuming the circumstances you would want to know about are more about the circumstances of the crime?
Correct.
Would you want to know anything about the defendant's background?
Only going, toward the insanity part, but.
Okay, and that was a confusing question.
Yeah.
I apologize. Okay, so insanity is a narrow legal definition that the defendant is so mentally ill, diseased, infirmed, or defected that he couldn't understand the difference between right or wrong, or he couldn't make his behavior conform with the law. Okay, so you may hear about somebody having mental health issues and think, I don't think it's insanity, so I'm going to find him guilty. But it could still affect whether you think life or death is the appropriate penalty. Does that make sense?
Yes.
Would something like that, would you want to know about that?
Yes.
The state asked you some questions about mental illness, right?
Yeah.
And if you thought it was real, right? And you do, obviously.
Yes.
Same general question, different topic.
Okay.
Do you believe racism is real to the extent that someone who experiences the effects of it, it could affect the outcome or the direction of that person's life?
Do I think it's real in the world? Yes. Am I? No.
Not a racist?
No.
Got it. Got it. Was not asking that question, but I understand. Do you think you could give meaningful consideration, and when I say meaningful consideration, I mean you hear it, you internalize it, you process it, and it could affect the outcome as to whether you think life or death is the appropriate penalty. Doesn't have to, but it could, right? As opposed to some people say, yeah, I can meaningfully consider it, but they're hearing it, dismissing at the same time, and that's not meaningful consideration. You know what I mean?
Right.
So do you think you could give meaningful consideration to a defendant who's been convicted of murder, the effects of racism on that person?
Yes.
Okay. You probably won't be surprised to learn this. There are folks that have differing opinions on all of these things. Fair?
Fair, yes.
And that's okay. The law contemplates that. And that's why death is never required. Because if one juror thinks that the verdict should be life, the verdict should be life. Are you okay with that?
Yes.
Mitigation can be anything to anyone. It does not have to be unanimous, and it can be unique to each juror. And it's literally just why one juror would choose life or not choose death as the appropriate penalty. With me?
Yes.
Sometimes the aggravation can seem huge, right? The murder of a law enforcement officer. The defendant's been previously convicted of another murder. And the mitigation can be something like a smile that's observed between the defendant and a family member. And for that juror says, I saw that, and for me, I assign the weight of life to that. And I'm not giving a death sentence in this case, and that's okay. With me?
Yes.
For a just verdict to be returned in this case, all 12 jurors' individual moral assessments about whether Mr. Loyd lives or dies have to be heard in this court. That's your duty, your right, and your responsibility. You're not going to bully or badger anybody to agree with you, right?
No.
Nor would you allow anybody to bully or badger you into changing your individual moral assessment.
Correct.
May I have just one moment, Your Honor?
Yes, ma'am. All right, either side need to approach?
No, Your Honor.
All right, ma'am. Let me take this off so you can hear me. We're going to send you through to the last round of questioning. That is the round where we will be picking the jury. So if you'll hand your badge to the deputy, please. The first thing that's going to happen is you are now a purple dot. The last group is purple. So when you call the number we're going to give you, you're listening for purple and what day you're supposed to return. I don't know the exact date. It's going to be next week. It's not going to be this week. So call starting Friday after 5. You're going to hear a message that tells you when to report. Okay? That day that you report, you need to have packed a suitcase because we're picking and sequestering the jury that day. So leave it in your car. You don't need to bring it in the courthouse. But if you get picked, we'll make arrangements for you to go get it. If not, obviously you're just driving home. There's a sequestration package in here, ma'am, that explains to you a little bit more about being sequestered and makes you, and kind of gives you a list of suggestions of things to bring.